And we're back.
Hello, everyone. We're so glad that you're here today. My name's Lindsay, and I'm the Director of Learning Experiences here at the National Speakers Association. And we are about to get started with today's amazing Academy Hangout on Air. So I'm going to turn it over to Liz Green, who is our incoming Academy Chair, and she's going to tell us a little bit about what we're going to learn today, and then introduce our speaker, Russ Riddle, who's going to share with you the intricacies and uncover the mysteries of not so really difficult intellectual property.
That is fantastic. So I'm Liz Green. I am your guide for the Academy monthly Hangouts, and one of the questions that I get most often as part of the Wisconsin Academy or the National Academy is, can I do this? And it usually has something to do with using somebody else's intellectual property. So I'm delighted to have Russ Riddle here. He is an expert in what we can and cannot do with our intellectual property because he actually went to school to learn about this stuff. So I often will say we should trust the people with letters behind their names. So he has the letters to say that he knows what he's talking about. Welcome, Russ. Thanks for being here.
My pleasure. Thanks for having me.
It is going to be a fun day to chat about intellectual property, and let's start there. Intellectual property is really our biggest asset as speakers. What the heck does that mean?
Well, there's four primary types of intellectual property. There's copyright, trademark, patents, and trade secrets. Mostly, as speakers, we deal with the first two, trademarks and copyrights. Copyright, think of copyright like content. It's the content of a book, content of your website. Those aren't the only copyright scenarios, but think of it as content, where trademark is more logo, taglines, one word, two words, a symbol, that kind of thing. You see them all over the place. You know, the most famous one's probably the Coca-Cola. The background is red, and the script is white. Coca-Cola, that's an example of a trademark. Patents are more inventions or improvements upon an existing thing. Not many of us deal with that in the speaking industry. And then trade secrets is something that's, again, to use Coke as an example, the Coca-Cola formula is uber secret. There's only a handful of people that know what it is. And so I think we'll be better served to spend our time today talking about copyright and trademark because all of us have those.
Right, and there's little things we all should do. For example, on our websites down at the bottom, there should be a copyright. And do we have to do anything special to get a copyright?
Well, there's a couple of questions there, but the first one, I get this all the time. How do I copyright something? Well, copyright is kind of like a jack-in-the-box. It pops into being, and I'll use the legal language, and I'll tell you what that means.
Okay.
The moment it's fixed in a tangible medium of expression, copyright springs into being. That means when you have ink on paper, or you have something saved in a hard drive or on a thumb drive, a tangible medium that you could hold in your hand usually, then copyright exists. You don't file with the Copyright Office to create a copyright. There are really good reasons to do that, to register, and we can talk about those. But that copyright, think of it as that jack-in-the-box. Whenever you've got it down on paper or fixed some other way, copyright springs into being. And you asked also about copyright notice. Yes, that's one of the ways we want to make sure we're telling the world that there's a copyright in this thing, and your website's a very good example. You'd want it to be at the bottom of every screen because people can print, take screenshots or what have you, and you just want them to keep, and it can be small. I used to have people say, I don't want to ugly up my stuff with all your legal language. Well, it doesn't have to be huge, just legible. And you've seen it, the circle C. Sometimes people spell that out, copyright. You don't need both. That's redundant. Sometimes you'll see the circle C and then the word copyright. Nothing really wrong with that except it's redundant. You'll see a year. The year stands for the first year that this particular content was published, put out there for people. And then you'll see words, all rights reserved. Don't really need the all rights reserved anymore on our notices in this country, but remember, World Wide Web. Some countries, they require that that's on there. And so you just put it on there. And again, it can be very small. And then there's also trademark verbiage if you have trademarks. But I don't want to just ramble. I want you to keep me on task here.
That was really good. And I think it's one of the questions that comes up is, should we refresh that year on our content? You know, when it turns 2015, should we have gone back to our websites and changed that to 2015? Or is it better to say, well, the first content I had in my book was 91. Should the copyright stay 1991?
If you make changes to it, and there's substantial changes, you probably should update the year. But most often, people leave stuff on there that's been on there from last year. They add stuff. They're always refreshing their content. So in those scenarios, I think it's the safest way to do 2014-2015. That way, some of the content was first published in 2014. Some of it was in 2015. So you'll see that a lot of times.
Okay, cool. Let's talk a little bit about trademark.
Okay.
Described what that was, the Coca-Cola, the Pepsi, those sort of things. I know that issue is actually how we met.
Sure.
Virtually. There was a question on the Facebook group for NSA about whether or not people should use the logos of the companies they work for or work with, whether or not that's okay to do. And it was a long, vibrant thread. And I think there's a lot of what people do versus what's actually right in this case. So maybe you can speak to that, just on what's actually right.
Sure. And as I was talking with you offline, you know, that thread, I was assuming that we're talking on the front end. Should I do this or not? And I always advise, let's do it the right way if you're on the front end. Of course, if you've inadvertently done something you didn't realize it was not proper and you get a lawsuit or something like that, I can always go into defense mode and make some arguments that would help you. But on the front end, yeah, you really shouldn't use logos on your materials of your clients unless you have permission. And permission can be as simple as an email. You say, hey, is it okay, so long as that person that you're emailing with has proper authority to grant that on behalf of their company. It can be an email. It can be as informal as that. You stick it in a file and just retain it in case there's ever a question. Some people put a clause in their contract on the front end that says, you give me permission to use your logo. The flip side of that is sometimes your clients don't want it even known publicly that they used people, vendors, and that sort of thing. So they'll have the reverse of that in there sometimes. And if you have that in your contract and you use it, then you not only have a trademark issue, you have a contract issue because they had a clause in there that you weren't supposed to use it.
Right.
So issues of confidentiality and that kind of thing. The reason that you don't, there's several reasons why you don't want to just start using it without permission. A, it's not your logo, it's someone else's. They've invested a good amount of money, time, and effort into that, and it's valuable. And so from an ethical standpoint, that's just not the right thing to do. So as you well know, one of our E's in NSA is ethics, and we want to try to always be on the up and up. And that's not to say that people that use logos are unethical. I don't know the situation in each instance. They may have permission.
Right.
But you don't want to. I hear people sometimes say, well, everybody does it. Well, that doesn't mean it's okay. Just, you know, the old trite saying our mothers and fathers used to say, so if everybody jumps off the cliff, does that mean you're going to go jump off the cliff? Yeah, that's not a valid argument. So there's an ethical issue. there may be a trademark infringement issue.
Right.
If people start getting confused as to whether Coca-Cola, I'll just keep using them to keep it consistent through here. If you had the Coke logo on there and you actually did training for them, nonetheless, are people taking the consumers that are seeing your site, are they taking the viewpoint, oh, Coke endorses her, or maybe she's affiliated with Coke, and again, it would be a case-by-case instance how you present it on your materials, but there could be consumer confusion, and then you get into infringement issues. There's also just the practicality of the client relationship. I've been an in-house counsel at companies, and our marketing people would do what you think would be a good thing. They go to a meeting and they've got their marketing deck, so they use the client's colors, logos, and all of that. Some clients would go, "Wow, that's great! You adapted our stuff and tailored it to us, and good job. We love that." Other companies, actual experience, they say, they get all cold and frowns on their face, and in the meeting they say, "Did you get permission from our legal department to do these things on your marketing deck?" And everybody puckers up, and the meeting doesn't go very well. So you never know. You never know. So you've got the customer relation issue, you've got ethics, you've got possibly trademark infringement. So it's just better not to do it unless you have permission.
Well, and when you do get permission, usually it comes with this is how our logo has to be.
Right. Right, and that's one of the things I would say to you with your trademarks. They're thinking the same way. To have a trademark, you want distinction. You don't want to be changing the color and changing the look all the time, and so they do. A lot of them have a certain, say, Pantone color that, with Barney, for instance, we had a certain Pantone purple that it was supposed to be every single time, and you have a brand Bible, if you will.
Right.
And so they will, even if they give you permission, they may say you can only use it in these ways, you can only use these JPEGs that they give you or whatever. It always must be XYZ.
Right. And I work with some medical device manufacturers.
Mm-hmm.
They, even what you call the product is very specific. It has to be this set of words, and you don't take a word out or mess with it. It's this, and it's abbreviated like this, and it's all capitals, but this one's a lowercase or whatever, because it can be very specific. And I know on that thread, somebody said, "Well, does it ever happen that somebody, a client would call you up or send you a letter and say, could you stop doing that?" And I had to raise my hand and say, yeah.
Well, I'll tell you, NSA has done that. I'm in the Dallas chapter, North Texas chapter, and somewhere along the way through the years, someone created it. It looked a lot like the official NSA logo, but they had to change the color a little bit and had written North Texas and a year and all of that. And NSA, in a very kind and gracious way, said, "Stop that. It needs to be this all the time." And so, yeah, that actually happens.
Well, and, even for those people who are not yet professional members,
right?
Unless you're a professional member, you may not use the NSA logo on your materials or website. So if you're in the, you can't slap the NSA logo up there. The NSA is pretty good about protecting their, as they should be. It means something to be the member.
Absolutely, and there's other companies that are increasingly strict. Well, I mentioned that I worked with Barney. PBS is very strict, for instance, very strict about use of their branding and logo. Apple is another one. So there are, you need to be very careful.
Yeah. Well, let's turn it around a little bit, because we've talked about how we shouldn't use other people's stuff. How do we make sure that we're protecting our own stuff right from the start?
All right. Well, let's stick with trademarks for a second. You need to use it. Trademarks, I said copyrights come in like a jack in the box once it's fixed in a tangible medium. Trademarks, you have to actually use them in the marketplace, use them in commerce. The old phrase, use it or lose it kind of thing. And so using it, being consistent, which we've spent some time here talking about. Also, you want to make sure that you put the trademark notice on your materials when you are claiming trademark in a couple of ways. On the mark itself, you'll sometimes see a superscripted TM to the right of it. You'll sometimes see a circle R. Let's talk about that a minute. There's common law trademark right.
Right.
And so even if you haven't registered with the trademark office, if you're making claim to a trademark and you're using it in the marketplace, then there's some value to that, some protection of that. So put your TM on it. You can never put the circle R until the trademark office grants your registration. Now, that's not when you file it. That's months later after you've gone through all the hoops, and there may have been a lot of back and forth. When you finally get the certificate, they say it is a registered trademark. Only then can you begin using the circle R. So you use either the TM or the circle R. Sometimes you'll see an SM. That stands for service mark, which is just a variation. Trademarks apply to both goods and services. And so if you're purely services, maybe you use an SM to be more specific, but using a TM is fine. You'll also, at the bottom of the page where you had that copyright notice, you would put, the NSA logo is a trademark of the National Speakers Association, or whatever the proper thing for them is. If Eliz Green had one in her personal name, it would be such and such as a trademark of Eliz Green.
Right.
If it's a registered mark, you'd say that. So you've got the symbol and the notice, and you continue to use it. Another thing you have to be careful about in trademarks is not just keeping the look and feel of it consistent so that it gets distinction. You don't want to let people use it generically. We call it in the trademark world genericide. And that happened. It's happened to some popular brands.
I can name one.
Pardon? What did you say?
I can name one.
Yeah, it almost happened to Kleenex. You're right. They didn't lose it because they took some remedial measures. But everyone would refer to every brand of tissue simply as a Kleenex. People used to do this a lot. Every photocopy was a Xerox.
Right.
It might not have been done on a Xerox machine. It's a photocopy. Jello instead of gelatin.
Right.
Vaseline instead of petroleum jelly. There were some trademarks that would have been very valuable that were lost in this fashion. Aspirin. Aspirin is a generic word. Bayer is a trademark. Bayer aspirin. Bayer is the trademark. Escalator, once upon a time, was a trademark of the Otis elevator. But people just started, no matter the brand, calling that thing that takes you to the second floor of the mall an escalator. And they allowed it to be used in that fashion. Linoleum, kerosene, I could go on and on. So you don't want to allow people to do that. The famous one that's happening today is Google it.
Oh, right.
We all say that. No, search online using a search engine. Yeah, of course, that's very cumbersome. So we simply say Google it. I'm not saying that necessarily Google will lose their trademark, but that's a way to remember. Don't let people do that to your trademark.
Right. And that's something to think about. I know one of our past presidents, Laura Stack, went through the process and got a registered trademark on Productivity Pro. And she's really good about defending that because that's an easy one for other people who perhaps want to move into that space to start, well, I'm, the Productivity Pro. Well, no, you can't be.
Right, because I am, yeah. And that's another way that you need to protect both your copyrights and your trademarks. You don't have to be nasty about it, but you do need to police it, is the phrase we use. It's easy to do an occasional search online to see if people are infringing on it. There are services that will do that for you at a fairly reasonable cost. So you need to take care of it. You can't just be turning a blind eye and letting everyone use it, because there may come a time that people would, or judge or jury would say, you know, you've acquiesced in it, and you
Right.
really have kind of lost the distinction because of it.
Excellent. So I know I have a note here about the difference between creating things as an employee or as a contractor and how that makes a difference.
Right. That's probably the single best piece of advice that we'll have on this webinar.
All right, I'm ready.
Yeah, you want to be very careful about this because nowadays we all outsource. We all use independent contractors. It might be an illustrator. It might be a web designer, whatever. A photographer. We don't have employees for the most part. I mean, some speakers have a staff, but I'm talking about for the creation of things, we typically outsource. Let me give you the law real quick, and then I'll tell you how you can protect yourself. The law presumes that employers own the fruits of their employees' creative things, just so long as it's in the scope and course of their employment. So if you truly have an employer-employee relationship, then the law is going to make a presumption that the employer owns it. But it's kind of the reverse with independent contractors. The law presumes that the independent contractor continues to own the copyright, trademark, whatever it is that they created for you. Yes, even though you asked them to, they agreed to, and you paid them. Unless there's things that you can do to make sure that doesn't happen.
Right.
It has to be a written agreement. So when you're using a contractor, an independent contractor to create things for you, then you want to make sure it's in writing. That's, you know, a lot of contractors will say, it's not necessary, you and I are buddies. Well, it is necessary for these purposes. It's not that you don't trust them. It's just because of the law. So you have a written agreement with all your independent contractors. And inside of that written agreement, you need to have two things. You need to have specific work for hire language that says, we agree this is work for hire for you. I'm doing this. There's no magical words as long as it's clear. You use work for hire in there, and it's for you and your benefit. But the problem with stopping there, and sometimes a lot of people stop there in their writing, is that under the Copyright Act, there's only 9 categories of things that are work for hire, that qualify for work for hire. And a lot of things that we might ask to be done don't fall in those categories. So you and I can call it work for hire, but if the law doesn't recognize it as work for hire, it doesn't matter.
Okay. So
written work for hire, and this third piece, add assignment language. And you'll see this in contracts. If at any time this is deemed not to qualify as a work for hire, then I hereby assign it to you in perpetuity. And so it's what we lawyers call the belt and suspenders rule. I got a belt to hold up my pants, but something could happen. I'm going to wear suspenders as well. You can have that work for hire in there, but what if something happens? Have the assignment language too. And it's very simple, and it's very standard. Independent contractors are used to seeing it. It's not going to be anything new to them. So it's very important as we outsource to make sure we do that.
So, for example, if I'm going to go get new pictures taken,
mm-hmm.
and I want to have the right to use those pictures as I see fit,
right.
I have a written agreement with the photographer that says I'm hiring the photographer for this work and that the copyright stays with me.
Right. Exactly.
Which is smart. And until we had this conversation, I'm like, wow, I bet if I were to go back and look at everything, and even the language that I write for other people's websites, I'm thinking I now need to add that to my agreement that they own that work, because I shouldn't have the copyright on that.
Right.
They should have the copyright on
yeah,
that.
and that'll give you a lot of credibility as a contractor that you put that in the agreement, that they
Right.
didn't have to bother doing that because you recognize that was important. There'll be a lot of people maybe watching this webinar that say, oh, I used and I didn't have it in writing, or what do I do? As long as you can go back, and I've got a form that I use that's really just a one-pager, certificate of work for hire, And it talks about, from the very beginning, we understood that this was a work for hire and you were compensated for that, and it has all the language in there. So as long as you still have a healthy relationship with that contractor, a lot of times you could circle back and get that done and put it in your file, but they could be deceased and their estate owns it now. You could have had a falling out. And they say, yeah, you and I don't really care for you anymore. And yeah, we agreed for that. Guess what? You're just out of luck. I own the copyright.
Right.
Is that ever going to happen?
It's going to cost you.
Yeah, or that. Well, for some extra money, yeah, I'll sign that. Typically what happens is you're still friendly and they'll sign it.
Right. But
you can't rely on that.
Right. And my husband's an attorney too, and these sort of getting things in writing is a good way to stay friends.
That's what I say. Contracts keep friends friends.
Right.
In some ways, it's just a piece of paper, but you both can always come back to it, because relationships. It's not just in marriages that fights happen. Relationships, issues come up because we might remember it differently. But you could always go back and say, "Here's what we agreed," and that tends to keep you friends.
Right. I believe in that. So let's talk a little bit about avoiding public domain landmines. So
the biggest one that comes to mind is people tend to think, incorrectly, but they tend to think that if it's on the internet, it's free game. No. That is just today's platform. It would be the same as if in the olden days when I was younger, it was just in a book or a hard copy of something, but it's a platform. Copyright still applies in cyberspace.
Okay.
Now, there may be a lot on the internet that's public domain, but you can't rely on that. I would suggest that more often than not, it's copyright protected.
So let's say, for example, there was a really funny Daily Show clip that just is perfect to illustrate a point that I wanted to make in my program. So I can't just embed that in my PowerPoint and show that because it's on YouTube, right?
Strictly speaking, no, you can't use that in your presentation because it's copyright protected. You need to go about, let me tell you how that's called a clip license that you would need in that instance. We all use sometimes a clip from a movie, a clip from a Seinfeld episode or a Daily Show, whatever it is. There's a way to go about getting a clip license. And most often, it's the easiest way is to go to the Motion Picture Licensing Corporation, and they are set up to do that. They contact the people. They may already have an agreement with those shows, and they can give it to you. It can be for X number of times in a given year. Sometimes it can be as cheap as a few $100s. And it's a business decision. Is this going to be a one-time use? Well, maybe I don't want to pay that amount, but if this is my signature keynote and I'm always going to be using that, or at least for the near future, it might be very worth getting that clip license. But don't just haul off and embed it.
Right. Well, I think it's confusing because I could share that clip on Facebook and make commentary on it that actually might make me look really smart, and that would be okay, because I'm just pointing to the YouTube clip that's already there. But correct me if I'm wrong, it's because I'm getting paid to present, and now that clip is part of my presentation that I'm getting paid for, that makes a difference.
Yeah. What we're getting into is the area of fair use.
Yes.
Most people have heard that phrase. And here's the thing to remember. It's always a case-by-case analysis if it ends up in court, and it's very unpredictable. It depends on the particular judge, a lot of things, and there's been cases that you would have sworn would be fair use, and they said it's not. There were cases that you would have sworn are not fair use, have been ruled that they are fair use. The problem is you're rolling the dice. It's always a gamble. But when you mention you're getting paid, that is one of the factors. Courts look at 4 primary factors. It's not exclusive to other criteria, but the 4 main factors in fair use are: what's the nature of your use of their copyrighted stuff? That's why news broadcasts can get away with sometimes putting things. How can they do that? Well, because they are reporting the news. That's a pretty standard category of fair use. Another one might be critique. You have book critics and that sort of thing. So how are you using it? Is it a nonprofit or is it commercial use? And most of us speakers are trying to make a living at this. And so it is a commercial use. Well, that's not going to mean necessarily always it's not fair use, but that factor would weigh against it being a fair use, when you're weighing all these factors. The second one is what's the nature of their work? Is it not been published yet? Is it published? What type of work is it? Is it a factual, historical thing, or is it a nonfiction? All those factors. The other thing is, how much did you use? And here's where people always want to know, well, how much can I use? How many words? How many paragraphs? How many pages? There's no rule of thumb. Obviously, the less you use, the better, but if you use the real heart of the work, then it's not just quantitative, it's qualitative analysis, and you may not be having a fair use if you tell them the outcome of the book, or that sort of thing.
Right.
And the marketplace, if you're really gutting their ability to profit from their copyrighted material in the marketplace, then you see how it starts weighing against this being fair use. And when I was at Barney, we would use songs. We had to do searches. Some of them were original, some of them were public domain, and we did the proper research to determine that. Some of them were famous songs. They said, well, how many notes can I use? Can I use? Tell me how many notes that I'll be okay. And I said, I can't do that. They said, oh, come on. And I said, well, what if it were 3 notes and you wanted to use the NBC theme?
Oh.
Bing, bing, bing. It's the whole thing. So I can't just say you can use 3 notes. It depends on what the work is. So that might answer the questions to some of the things you were going into. You did mention, and again, I don't recommend on the front end, but if you use something on Facebook and made some critique about it, you actually were saying, I don't think this was well done, here's why, and all that. You might have an argument of fair use. I'm not saying it necessarily would be decided that way, but it's not like you were just throwing it in there and saying, making a profitable point. You were critiquing.
Right.
Does that make sense?
Right.
I don't want to bog down too far because fair use gets very complex.
It does.
I would just say the better course on the front end is to get permission, because if you're going to rely on fair use, you're rolling the dice.
Well, and that's, when we present, oftentimes people are using some video clip or music, which you already talked about, or pictures, which is the slippery slope, I think.
Right. Let me hit on music just a little bit more, because there's a couple of things I'd really like to. It's just me over here and some interference there.
Thank you.
Okay.
It is.
Well,
Go ahead.
On music, there is 2 copyrights typically. There's a copyright in the song, and there's a copyright in the sound recording. So if you're going to use music, it may be that you have to have 2 permissions. The song copyright is typically owned by the writer or the composer's music publishing company, whereas the recording itself is typically owned by the record company. So remember, there's 2 copyrights there. But the Harry Fox Agency can take care of getting some permissions for songs for you for a fee. That's pretty easy. Also, you can sometimes get blanket licenses from ASCAP or BMI for so much a year. You can use anything in there, but you can use the song that way. You can't necessarily use the recording, because those are different. Mechanical licenses deal with the song. Master use licenses deal with that recording. So you could use Hey Jude by getting the permission from the Performing Rights Society, but you could not use the Beatles recording of Hey Jude because that's a different copyright. Does that make sense?
It does. And I know I was just chatting in the chat box with Lindsay about NSA does have an agreement with BMI to get a discount on licensing fees. So if there's a song that you want to use, that's a good resource to call the NSA office and ask how this works, or email, as Lindsay said,
Sure.
the NSA office and ask, okay, how do I go about doing this, and they can make the right connections. It's as a former dance teacher, using recordings is something that you have to be really careful about for commercial use. And there are, God forbid you use a Disney song.
Yeah, they're very strict.
They're very strict, and they are going to find out. I don't know how they find out, but holy cow, you will get a later. Pardon?
The small world, after all.
Exactly.
Hey, Russ, we had a couple of questions that I wanted to interject in. I have a person here who is just getting started, and they're wondering, is there a checklist, maybe a top 5 items? So they're putting together their presentation for the first time. What are the top 5 issues they need to be aware of, both thinking from an intellectual property to protect their content, but also if they're featuring audio or video or a picture of some kind inside their presentation?
Okay. Well, I think that number one, remember to take care of your intellectual property. So you want to make sure you own it from the outset. That gets into is it a contractor or your employee that we talked about earlier. You want to make sure that you're putting notices on your stuff, copyright notice, trademark notice. You want to make sure you're policing those things. You're checking to see if people have things online that's yours. You want to make sure that you have things in writing as much as possible. I don't know if I've counted 5 or not.
Yeah.
In terms of using other people's stuff, get permission.
Great. And then for common creative licenses, that's a question that came up around intellectual property, and I know you kind of touched a little bit on attribution, but can you talk a little bit more about common creative and how the licensing might work for a speaker just starting out that is unfamiliar with those rules?
I'm getting a lot of echo. Liz, can you repeat that for me?
So the question was about common use. I'm not sure I understood the question. I think Lindsay's typing it. But while we're waiting for the question to come up, let's talk a little bit about, if I wanted to use a picture, how do I go about getting to use that picture?
Well, you have to determine who owns the copyright. Back in the day when I was younger, Olin Mills, remember Olin Mills? They would always have on the picture Olin Mills and their copyright noted, Circle C and the year. And so you knew pretty clearly that was Olin Mills you needed to get permission, even though it's a picture of you. You own that physical picture, you bought it, but you don't own the copyright in it. So you would have had to go to Olin Mills to get permission to start repurposing that all over the place. Today, when everything is in the JPEG world, it's not always quite as easy. You just want to make sure, go try to find out who the photographer was. That's the first place to start.
Well, and a lot of times you'll see the watermark over top. So the question was actually regarding this, the common creative licenses. So what's the difference between using something off of Flickr versus using something off of iStock Photo?
Well, there are copyright commons licenses, and there's really 3 kinds of scenarios. Something is totally in the public domain, which you need to make sure of, or something is copyright protected and you have to get permission flat out. Or these days, there are a lot of things called Creative Commons where the copyright holder is putting them out there for use and saying, here are the rules. You can use this so long as you use these rules. And you can't go beyond that. They have set the parameters, but you don't, if it's in a Creative Commons thing, you don't necessarily have to go get permission. You just have to make sure that you're following the rules that they set.
And usually those rules include you got to tell people where you got this.
Right.
So it'll have a photo credit, for example, photo courtesy of whatever.
Right. And I think that's always a good thing to do no matter what. Even if it doesn't make you, it's not a defense to copyright infringement that you credited necessarily. It might keep your damages lower that you're showing good faith, but it's always a good thing to write in Creative Commons. They're saying a lot of times, so long as you give that credit. So that's one of the rules. The other thing is your credibility. If people know that you're just using stuff left and right, and they know that's not yours, and there's no mention of anybody else, it can, chip away at your credibility. It gets into ethics.
Right. Well, and those things are really closely related when we come to intellectual property, because there's a lot of this you could just get away with.
Right.
But it doesn't. Right.
And that's sometimes I think that's where our discussions go, in the back and forth, and the online thread or even in a discussion. Everybody's doing, oh, come on, they're not going to do anything. It's not really that bad. Well, is that the right thing to do? I mean, if we're having those kinds of discussions, it's fine if it's an academic debate, but ethics is real important in every space, but certainly in the NSA space. And if we're looking at it of what can I get away with, it seems to me that we've turned it on its head, and we're not looking at that in the best light.
Right. Because we could all get away with a lot of stuff, and we wouldn't want other people to treat our content that way. I mean, we get really offended when somebody uses our signature story or whatever. We have to be as ethical about other people's stuff as we would want people to be about ours.
Yeah, that's right. I mean, how would you feel? You're right. You'd be upset. So respect other people's intellectual property just like you expect them to respect yours.
The everybody does it isn't really the way
that
to go.
Doesn't hold any kind of water.
No. Now, we talked a little bit about licensing opportunities. Is there anything else you wanted to share with us about that?
Well, licensing can be an offensive thing for you too. We've been talking mostly about when you want to use other people's materials, getting the proper license. But for instance, you may want to license other trainers to train your materials. So you can turn it into a licensing opportunity where you train them, certify them, and you get some upfront money, and then they have to, for instance, buy the material from you, so you're getting some back-end money, or maybe they pay you a percentage. So it works both ways, the license.
Right. The one thing that just popped into my head that I think a lot of us come up against is, let's say you did a webinar like this today. Who owns this webinar?
My understanding today, this would be owned by NSA National.
Right. Particularly because, of course, we're not getting paid for this.
Right. I mean, we're doing this on their platform, in their name. They've asked us to do this. I would suggest that the copyright's owned by National.
But let's say we were asked by a client as part of a contract to do some webinars as a follow-up to our keynote. And so I'm going to do a webinar 30 days after to just, make sure people are following through. If that's created as part of my contract, clearly I should be talking about who owns that content and whether or not I can then put it out on my website as a new product or not.
Right, and that would be a little bit different than what we're doing here today, because I'm covering areas of law which are facts. I'm not really presenting material that I've created, and so The scenario you just mentioned would be a little bit different. It'd be kind of like the music category, where I said there's a different copyright in the song itself and the sound recording, and they may not be the same owners. The same might be true in the situation of a webinar. And this could all be agreed however you want to in the contract, but if you didn't have a contract, your content that you're presenting is yours. But if they, the production, they send in the camera and the crew and all of that, there can be an argument that they would own the actual recorded webinar. That does not mean they own the content. That's your content. So it could be kind of like music. There might be a couple of copyright issues there.
Right. And I would imagine the same would go if we're performing a keynote presentation and it's recorded.
Exactly.
I know in my contract it says I need to have that recording. I need a copy. If you're going to record me, I get a copy of that, and it's right in my contract, with the understanding that it's mine. I get to use it.
Right.
Which I would imagine is a good thing to have in your contract.
It is a good thing to have in a contract, but it doesn't mean you own the copyright in that sound recording. Again, you do, of course, own the content of your keynote, but you want to make sure that I get a copy of it and I can use it however I want to in all media, and I can help you with language for that. But you see, it starts getting complex when there might be a couple of different copyrights involved.
Which would bring me to one of the points that I'd like to make, is that if you're listening to this and your head's kind of going, there are professionals in our world that we need to access. I strongly recommend to my Academy people that they have a really good accountant, because taxes for an independent contractor are complex.
Sure.
I think you should have access to an intellectual property attorney, in that these issues are really complex. And, without a professional whose whole career is about being steeped in these issues, it's hard to know sometimes which direction to go.
Right, because it starts getting complicated, as you said, but I have an app for that. Me.
Right, and it is wonderful to have you as part of our association. And if you're watching this and you haven't made plans to go to the National Convention in D.C. this year, you really should, because you can get a whole breakout session with Russ about how to protect your cash cow, which I love. What was the title? I can't remember.
Corral your cash cow.
That's it. That's it.
Yeah. It is. I mean, your most important asset, if you have a staff, are your people. But aside from your people, your IP is your lifeblood. I mean, that is your most valuable asset. You want to make sure you protect it. Don't mean to do a shameless plug here, but yeah, it's Monday afternoon at the convention at 4:30.
Yes, be there or be square. Or be sad because you missed such good content. Because I know we got a lot today, but I'm really looking forward to that session. I know we have just a few minutes left. Lindsay, do we have any other questions that we need to address? No, she's shaking her head no. Well, we had a shameless plug for the convention. Is there anything else we should shamelessly plug?
Media Lab coming up.
Media Lab!
11th, where we're going to talk even more about intellectual property.
Yes. And yeah, that the whole media and media use, that's a whole other area we could delve into in that arena.
Absolutely.
Russ, anything we should have asked you that we didn't?
I don't think so. I could go on and continue in the semester of copyright or the semester in trademark, but I'll save some good stuff for the convention.
That sounds good. I'm really seriously looking forward to that session. I know that this stuff is very complex, and I so appreciate how approachable you make it.
My pleasure.
That was wonderful, and I appreciate you being flexible with the time and the day, and just giving so generously today.
Thank you for having me.
So, and I'll hand it off to Lindsay.
All right, thanks again so much, Russ. We appreciate it. For Liz for sharing your time today. We hope that no matter who you are, your house is warm, even though it might be snowy out there. And we will see you at an upcoming event, either at your local chapter or one of our national NSA meetings online or in person. We'll see you again next month for our March Hangout. So thanks so much and have a wonderful day.
Thank you.